So we look at the case of a state of Shafer versus the IRS. And the question in this case is whether the estate actually possesses and owns a lot of land, because if it does, then the sons who inherited Shafer's estate owe back taxes to the IRS that they haven't paid. And so the sons of Shafer, who now are the heirs of Shafer, claim that Shafer never actually owned the land. That Arthur Shafer, their father, never actually owned the land because he never paid for it and it was never transferred to him. So in order for the IRS to prove its case, what it wants to show is that one of the sons executed an affidavit in which he said, my father always said he owned this land, and had given this document previously to the IRS, and one of the sons of Shafer, actually both of the sons of Shafer, now want to say, you can't consider that thing that we previously gave you because it's hearsay. It's an out-of-court declaration, admittedly by us, that's being offered for the truth of the matter asserted. And the Court of Appeal says, no, you have to look at the definition of hearsay and its exceptions. There's a provision in the definition of hearsay that says a statement by a party, and this is all 801, a statement by a party is not a hearsay. It's not hearsay, nor is a statement by that party's representative. And so the question now are the sons of Shafer parties to this litigation? And they are, because they are the heirs of Shafer. They are now the people who will take Shafer's estate. So they are in fact parties. But this particular affidavit has two potential problems with hearsay. One is the affidavit itself hearsay? And then the affidavit reports what other people have said. So, the sons of Shafer write an affidavit in which they say, Dad always said this was his land. So you've got the affidavit that reports what the father said. So if there are not hearsay exceptions for both the affidavit itself, as well as the information contained within the affidavit that comes from another party. So you got the writer of the affidavit, and you got the writer of the affidavit saying what someone else, Arthur Shafer, the dad, had said. So you have to have hearsay exceptions for both the affidavit and then any additional potential hearsay that would be contained in the affidavit. And so the affidavit itself, yes, there's an exception for that under 801. This is a party admission. The sons of Shafer are now a party to the action. What about Shafer himself, Arthur Shafer? When the sons say in the affidavit, Dad always said this was his property. Well, he's a party as well, because as the deceased, it's his state, and so he's his estate, and so he is regarded as being a party to the litigation as well. So you have here two levels of parties. The one party, or the parties, the sons, write the affidavit. They're parties to this litigation. Anything they say is now admissible against them, as you always hear in the criminal context, in the Miranda setting. So anything a party says can be admitted against the party. And then within that affidavit, you've got the statement of the dad, and the dad is also a party. So this rule is governed not only by the rule of party admissions, but it's also governed by Rule 805, which talks about hearsay within hearsay. So you have statements of others within a statement of another. Each one of the provisions, like the affidavit as well as the statement within the affidavit, both of those have to satisfy an exception to hearsay. So that is the estate of Shafer versus IRS, and it governs party admission.